Hi, my name is Perrotta, an attorney here with the Cannabis Legal Group in downtown Royal Oak, Michigan. Today I'll be discussing a specific issue within the context of mergers and acquisitions for cannabis licensed entities in the state of Michigan. And so we hope you find this information informative and enjoyable. And if you have any other issues or questions regarding any aspect of your licensed cannabis facility, or even issues discussed during this presentation, we look forward to your outreach and in potential working with you in the future. So today's topic will discuss mergers and acquisitions of cannabis licensed businesses in the state of Michigan, and specifically earnouts. So in its simplest form, an earnout is a potential payment or payments made post-closing to an M&A deal that are based on certain triggers or considerations to be achieved by the target company. Now, these triggers could be financial triggers, such as earnings, gross revenues, even of a specific licensed entity, especially if the target entity has multiple licenses, or they can be non-financial considerations, such as full licensure or pre-qualification if the entity being acquired is a not yet pre-qualified entity. So those are just some of the types of earnouts that you'll typically see in a cannabis merger and acquisition deal. The legal cannabis industry in the state of Michigan is still in its nascent stages, but we are starting to see some industry consolidation with regard to mergers and acquisitions. Not quite to the extent that we're seeing in other states like California and Colorado, but that is eventually coming. And again, we are starting to see that now in terms of various sized licensed entities gobbling up other ones, or just other entities looking to cash out or to be acquired by other entities in the state of Michigan. So specifically, today's topic will deal with earnouts as part of closing, getting the type of acquisition deal to close. And so these are important to understand, especially in light of the way the legal cannabis industry is structured here in Michigan, where there are various phases to licensure. There's a pre-qualification stage and a full license stage, and then also the ability of cannabis entities to stack either the same licenses or to hold multiple licenses. So you can spin off different industries or different licenses that you want to sell as part of an M&A deal. So earnouts really come into play when there's a difference in valuation really in the target entity. The buyer, potential buyer, values the target at a certain amount, and the seller values at likely to be a higher amount. So in order to bridge that valuation gap, an earnout is usually negotiated between the parties. Again, an earnout sounds simple, but the point of this presentation is to keep everyone who's negotiating the terms of the deals to realize that it's critically important to avoid any post-closure issues regarding the earnout in terms of tying up all the loose ends beforehand in the definitive agreements, to really specify how the earnout is going to be achieved and the conditions under which it will be achieved. So really, earnouts can take several forms. They can be tied to specific performance metrics of the target company, and as they relate specifically to cannabis companies, those performance metrics could be gaining pre-qualification or gaining full licensure, or another sister entity gaining local approval in a municipality that comes on board to approve cannabis in that municipality. Or they can be tied to certain financial metrics, which is most often the case that you see, or by gross sales achieved during the earnout period, which again would be specified in the contract. Of course, one of the other considerations is if there is a deal that requires an earnout in order to close, the seller, of course the buyer, they want to be careful regarding the limitations that you put on the buyer in order to fully control that business, potentially to the detriment of the seller who's trying to achieve and earn that earnout post-closing. So that's always a complicated issue and a thorny issue between buyer and seller to negotiate those terms, and really the limitations on the buyer so that they don't potentially spoil any of the earnout that's earnable by the target entity and its members. So these are the various issues to consider, especially in light of the wide range of valuations that companies can see and be subject to, especially those companies that are at the beginning stages of licensure. They may have some tangible assets and value to the company, but the entity may only have pre-qualification. And so part of the earnout could be how quickly the target entity achieves full licensure in the state. And then you can tie an earn-out amount based on that. If we're talking about a fully licensed entity that is subject to acquisition or merger into a bigger entity, it likely makes more sense to have those earnouts tied to financial considerations as opposed to non-financial implications as well. So the idea is, of course, to structure the deal that is workable, that gets you to close, and that both sides are happy with in order to avoid any post-closure issues regarding that earnout. And so this is why it's critically important to hammer out these issues beforehand and to really spell those out with competent legal counsel, as well as financial advisors and CPAs that are going to be an intricate part of the deal to make sure that any valuation gap is ultimately bridged by the nice terms of the earnout that both sides can agree to in order to achieve the deal. In addition to some earnouts issue, there are some other issues that are prevalent in a M&A type deal, specifically within cannabis. Those involve restrictive covenants to the members of the target entity. These will get it outside of the context of earnouts. If there's no earnout, if the valuation of the company can be agreed upon fairly easily, we want to make sure that the restrictive covenants are at least on the buy side, are strong enough to prevent a seller from going out and competing with the newly targeted entity that's been acquired. So these are considerations that we would like, that we stress to all of our clients that are undergoing an M&A deal. But in light of the current marketplace in Michigan and really, again, the beginning stages of some industry consolidation, these are some issues that we've seen and we anticipate to see in the future regarding the haggling for terms of the specific terms of an earnout. So in addition to this topic regarding earnouts in the context of a merger and acquisition, we encourage you to visit our website and our YouTube channel for other topics regarding other areas of interest for your licensed cannabis business. And we encourage you to also visit our website at cannabis-legal-group.com.